Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
So hi Chucky, hi to all our listeners. Welcome to part 2 of this episode. So Kim, moving on now to the actual process for selecting and appointing arbitrators. We've had a look at the international arbitration rules that JAMS sets forth. We note there that party autonomy is foremost, as one would expect in the context of international arbitration, and that the parties make a choice or have the opportunity to in the first instance, but then we move to a list procedure. Would you better talk us a little bit through how that works and how JAMS supports the parties in that context?
Yeah, so the majority of cases that we see are in arbitration come to us without an arbitrator pre-selected. And often when there's the exception is when there's a tripartite arbitration proceeding, generally the parties have appointed their party arbitrator, and in most cases they've come to select a chair together. In those cases where they haven't, we can assist them by providing information about the qualifications of our neutrals. As part of our screening process, we try to gain an understanding of sort of the subject matter of the dispute. And if the parties haven't been able to agree upon an arbitrator, then we provide a strike list. And that strike list is tailored so that it meets whatever the contractual requirements are, depending on the experience of the arbitrator or perhaps language or experience in a particular part of the world. And the subject matter, and then we cultivate a list and send that to both sides, and then the parties can go through the strike process in order to come up with an arbitrator. We have currently about 437, I think is the latest number of neutrals on our roster. And so when we create a strike list, we pull from that list. If the parties indicate that they have a particular person in mind, then we can work with them and work with that external arbitrator to ensure that the parties have their needs and qualifications met.
Excellent. So from that 437, what's the sort of balance in terms of, US to non-US or particular geographies which are represented? How many are from London?
We right now have, I think the latest number in London is 13. We have a number of our US-based neutrals, though, that frequently arbitrate cases in London and elsewhere. And I'd say currently right now, I think we have in cross-border matters, and I wouldn't limit this just to arbitration, but cross-border mediations and arbitrations, we've got, I think, currently about 100 people serving on different cases that are currently open and ongoing. And not all of our arbitrators would be people that would even maybe feel qualified or be interested in serving on a cross-border case. And so we limit our strike list and our recommendations to those that we believe are qualified to hear and to arbitrate a case under our rules, but also under any other provider rules. And we've got a number of qualified people to do that.
And Ranse, what's the appetite within JAMS to expand that range of neutrals? And is there a move to try and recruit, if that's the right word, more internationally?
Well, always, and yes. And I would also say that, again, COVID has given us another opportunity here. Because, as you just mentioned, which panelists are located in London, which ones are in the US, and it used to be very much about where are you located, therefore that's where you can potentially hear cases, or where was it easy for you to travel. Now I think that's very, very different. With the geographic boundaries have dropped, and people have become a lot more flexible, and they can become easily very international, very, very easily. We are strong supporters of the pledge, and we have certainly always encourage and look for opportunities to develop and enhance certainly those individuals that we say would be the panelists of the future. And I think part of the issue has always been about pipeline, which individuals were in either going to be leaving the bench or finishing their law practice. And so that's traditionally where we would potentially get mediators and arbitrators. What we're actually seeing now is people who are younger who are saying, I'm really interested in becoming a full-time neutral. That's something that's really useful for me to consider. And JAMS has a variety of different mechanisms about how we can support and encourage that move from a traditional practice into being a full-time neutral.
So one of the things you mentioned was the pipeline and trying to build a pipeline instead of waiting to recruit people until kind of the end of their practice or when they leave the bench. So one of the issues that I think you face with that is generally you only have full-time neutrals. Is that right?
So our model is to have individuals who are exclusive to JAMS and are full-time neutrals, and there's a variety of reasons for that. First of all, it reduces the challenge of having any conflicts, and we want to make sure that we can there's a broader opportunity for them to get appointed as possible.
The challenge is, so our model, as Ranse said, has been to have full-time neutrals that are exclusively managed by JAMS. And so we have traditionally looked to people coming off the bench or who are at a stage where they can leave their law practice. And there is a tension in that with also building a pipeline. And we recognize that. And we've made some adjustments so that some of our people that we've engaged with internationally are exclusive to us in terms of the business that we generate for them from the U.S. And then they may still continue to engage with a chambers or a law firm for other appointments. But and in the U.S., we recognize also that we need to look for other ways to support sort of a younger, more diverse pipeline of people and potentially build in some flexibility in our model. One of the reasons that we have been concerned about people coming on board and continuing to practice law is because it does create conflicts of interest. And we have, as you know, with 400 plus neutrals and 18,000 cases we administered last year with thousands of law firms and lawyers, you can imagine the potential conflicts both on the law firm side and on JAMS side if we're having to check conflicts across all those firms and across JAMS. And we also have to adhere to very strict disclosures, and I mean disclosures in terms of conflicts of interest at the outset of a case, because several of the jurisdictions in the United States have very strong regulations about that. And so we want to ensure that we're adhering to that and that we don't create problems for the confirmation of an award or for challenges in the middle of a case. So that's why that has been our model, but we also recognize that we need to look for some flexible ways to support a more diverse across all categories base of neutrals, and we want to be able to ensure that we're helping to build the future of arbitration beyond our current model.
Thank you for that. So the next topic we're going to talk about is diversity. So one of the things we saw, which we were very, very impressed with, was the great achievement that JAMS was shortlisted for the GAR 2020 Equal Representation Arbitration Pledge Award. So congratulations for that. And I understand that was based on a couple of initiatives that you have in place. And Kim, you had mentioned some earlier, but let me turn to you to go a little bit deeper in some of the initiatives that you have in place.
It's been a really interesting journey for the last, as many years as I can remember. We have been well aware that while our employee population is very diverse, we have pretty much half of our employees are diverse. We've got almost half female, and that's across, our entire organization and up through our senior management team. Where we have struggled is on our neutral side. And part of that is because of the pipeline that we talked about before, where we had traditionally recruited from law firm partners and from judicial officers. And if you look at the sort of the diverse makeup of those stakeholders or those organizations, it's roughly the same as ours. So while you look at our roster and you see women and you see diverse people on there, it's not enough. And the challenge for us is because we want to ensure that if somebody comes into the organization, that we can provide work for them, that they can be busy as they want to be, and have, a steady stream of cases. But ultimately, the parties choose. We can put names out on a strike list. We can promote. We can ensure that those people are put forward and that their qualifications are recognized. But at the end of the day, the marketplace is choosing those arbitrators. And so we decided at one point that taking a cue both from the pledge that had been initiated, that it was designed to promote more gender equity in arbitration. Also, the Hollywood, the entertainment business had started to talk about an inclusion rider to make sure that any film project, movie project, television, that there was a commitment by the organizers or the producers to have a more diverse cast, a more diverse, staffing all around. And so we decided that we would develop some language that would parties could insert into their arbitration agreements that would encourage them to consider diversity, because it's very important, we think, for good decision making, and it's important for the parties in an arbitration to understand that they can choose someone that has their same background, or maybe has had similar life experiences, or just basically can just have a bit more perspective on the dispute and just bring greater decision-making processes to the dispute. And so we created this language and we included it now, and it's available in our clause workbook. We're not tracking who's including it or who's not including it, but I'm hopeful that it is making a difference, and it will cause people to stop and think and make different choices. At the same time that we're actively trying to recruit people onto our panel that more accurately reflect society, and so we have a different representation going forward. And we, again, we're struggling with how to move that needle, and decided that it was important enough to us that back in 2019, we engaged and retained a full-time diversity program manager. Her name's Joanne St. Louis, and she's been very helpful in helping us to bridge our business and work with affinity bar associations and to support those organizations, and also to potentially identify new people that would be helpful and that we could work with on our panel. And so we've been very proud of those initiatives, and even over the past year, there's been so much discussion about race and racism in the United States, and we've tried to tackle that head on and make sure that our organization is aware of the need for diversity and the need to for equality and for inclusion across the organization. And it's one of our key goals and key priorities. It has been for some time, but probably even more so today.
Thank you for that, Kim. And I think that the initiatives that you're putting in place are wonderful. I was on a panel where we were talking about diversity in arbitration yesterday, and one of the things we talked about is one issue with actually increasing the number of diverse neutrals is that there's so many stakeholders in the process. So you have the institutions, and you guys are doing what you're doing, but you also have the lawyers, then you have the clients, and all of these people have to be aligned on diversity in order for there to be true change. And having the clause and actually putting upfront in your arbitration agreement that you should consider diversity when choosing a neutral, it kind of brings it to the top of the mind of the other stakeholders in the process. So the lawyers like Kwadwo and I, as well as our clients, when they're making decisions on arbitrators. So I commend what you're doing. Ranse,
Thank you. We think it's very important.
Yeah, and one of the other things that we're also doing as part of our awareness raising and our thought leadership is considering what other impediments or other challenges are going to do we see, and that will face individuals either appointing international arbitrators who are from a variety of different minority backgrounds, or having the opportunity for women to be selected, or a variety of other challenges. And that's the impact of COVID, and also how people are going to our minorities will be disproportionately impacted as a result of this virtual working. And we have a webinar which we are presenting next week with a fantastic group of women, female arbitrators, who are going to talk about some of the impediments and the challenges they see, not only in law firms, which will of course have an impact on the pipeline, but also those individuals who could be selected as arbitrators. And what can we do as an institution and as thought leaders, and to make sure, first of all, to recognize there is a potential issue there, and what can we introduce to make sure that that doesn't be something that is a foregone conclusion.
Do you want to pitch the program? I don't know that we'll get this recording out in time, but maybe people can go see it after the fact.
It's on December the 15th, and the information is on our website. Not only that, though, if you can't make it, we will have a recording available that will be made available shortly afterwards.
Yeah, thank you for that. Kwadwo?
Right. Well, yeah, I'll certainly try and log on for that. That sounds really, really interesting. And yeah, once again, echo what Chucky's saying about really commending the efforts you're making. You're really at the forefront of some of these initiatives on diversity, and we think that's something incredibly important for international arbitration. Moving to the next subject, I'd like to talk a little bit about provision for clerks and tribunal secretaries in the context of international arbitration. Now, we've seen this debated quite heavily in a number of jurisdictions. There's certainly a couple of cases from the courts here in England where challenges have been made on the basis of alleged involvement or alleged excessive involvement beyond the initial terms of reference by a tribunal secretary. Now, we note that JAMS provide for that, so we'd like to really hear about how that works from JAMS' perspective, and what perhaps safeguards or measures you might put in place to ensure that it all runs smoothly and really enhances the process rather than creating difficulties.
Right. So I will start out by saying it's not used in every case, but I think that it has been becoming more common, and particularly for more complex cases. But our arbitrators have to get approval of the parties before they can engage with a clerk or a tribunal secretary. So that has to be explicitly agreed to at the outset. And that clerk or secretary has to make the same kind of disclosures about potential conflicts of interest as the arbitrator, so that the parties have full knowledge and fully informed before they provide that consent. And then they also have to make sure that they're very clear about what the clerk or tribunal secretary's fees are going to be, what additional costs that's going to incur, and also to the extent to which that clerk or secretary is going to be involved in the research or potential writing, and that it is the arbitrator's duty to render the ruling and to make the decision and to issue the final award, and that they should not delegate that authority to a non-arbitrator. And then if in most cases, that's going to be an additional cost, and so the parties have to agree to that, and it has to be very clearly disclosed and very transparent at the outset and throughout the proceedings.
I see. And presumably the additional cost of engaging the clerk or the tribunal secretary, one would hope would be saved in making the time spent by the arbitrators themselves more efficient.
I think that's true, and I think that's why you do see parties agreeing to it, especially if it's an arbitrator that they've worked with before, or somebody who's judgment and decision making and the management of an arbitration is something that they trust, and yes, it can very much provide for efficiency and for cost savings.
Now, before we came on for this podcast, I was having a look at your website and noted the guidelines you have on tribunal secretaries and clerks that you have up there. Now, one thing that stood out for me, certainly compared to some of the other guidance provided by other institutions, is that they are very punchy, brief, and to the point. And that's certainly very, very welcome from my perspective, and really made them stand out. How have you found that they've worked in practice?
I think that they've worked well. We don't get complaints about them, and I think that it provides good guidance for arbitrators, and I think that they adhere to those pretty regularly, both for international cases and for domestic cases where clerks weren't used very often, let's say 10 years ago, but are now much more common. And parties embrace it, and they seem to be happy with the process, and generally we don't get any complaints about it.
Oh, great to hear that's working well. So, Ranse, do you see, particularly now these use is becoming more common and prevalent, any need to perhaps either expand or update the guidance, or is it a case of carry on, and if it ain't broke, don't fix it?
Well, I think that, one of the things that, we've mentioned before is about having efficiency and something that's effective. And so unless, of course, we see there's a need, as you know, when you start to redraft and you start to reconsider anything, it takes some time. I think maybe there could be an opportunity, potentially with the development of a hybrid practice, but that's certainly something we'll keep an eye on.
Oh, that's interesting to hear. So, talk on the subject of updates and developments. Over back to you, Chucky.
So we talked about the rules changes throughout the podcast, but I understand that you have some plans and initiatives in place to educate users about those changes once they come into place. Can you tell us about those, Ranse?
Well, certainly, I think what's really important is that clients and potential future users really understand, what the International Arbitration rules contemplate and why they should use them. So one of the things we're going to be doing is partnering with other institutions and maybe other multinational corporations and law firms, and really have a conversation about how you can use them, when you should use them, and how you could use them. This would happen both in the US and outside of the US in Q2 and Q3 of next year.
Thank you. Kwadwo?
Thank you. So I was moving on briefly to another subject. Something we've picked up from the talk and discussion we've had so far is that obviously JAMS offers much more than simply arbitration. Would you like to say anything else about the mediation and other ADR services that you offer?
Well, certainly, particularly, if we go back to the impact of COVID, what we're seeing is that the businesses will need a whole range of offering, and certainly, and this goes beyond the traditional mediation and arbitration. They'll need to have a flexible range of offering that potentially will have an expedited element, and also potentially some form of facilitation, or maybe even contract renegotiation or restructuring. And certainly our facilitators, our mediators, our arbitrators can provide that sort of assistance. So we have the traditional services and models that we currently have. But what we're also doing is we're listening to clients, and we're also identifying what are some of the trends that are developing as we're going through into 2021, and say, we recognize in this particular sector of this industry, there is this particular potential challenge and concern. I think that what we need to do is have a conversation about what are your needs, identify the needs, and provide a sort of a solution and a framework in order to assist.
Excellent. And then among your body of neutrals, as you mentioned, you have facilitators, mediators, arbitrators. Do you see the facilitator role as having a different skill set perhaps to arbitration, or are you drawing from the same individuals who are just sort of putting on a different hat or a different approach for different circumstances?
Well, I mean, certainly, when you consider what is required from a facilitator versus an arbitrator, that potentially you could say they're different, but I think they're very, very, very much the same. It's about individuals having experience and understanding about what is required, what is needed, but also listening and working with the parties as well. I think the most important thing that what we try and find is to provide the most appropriate solution to meet the needs of the clients, for it to be effective, to be efficient, and also to have a result that they can depend on.
Right. Well, no, that certainly makes good sense, and as I say, very commendable, and I think very practical. Thank you.
So the final question that we have for you, Kim and Ranse, is just about what your predictions are for the future of international arbitration. Anything that you want to tell us that we haven't discussed today. So let me go first to you, Kim.
Well, international arbitration was growing prior to COVID, and we only expect that that's going to continue to grow. It's a little uncertain in terms of, on the one hand, you have deterioration in U.S.-China relations, and maybe that will be reset in the coming U.S. administration. But we're thinking that that's going to have some downstream implications for contract disputes, and will probably cause those to increase. But it's hard to know for sure. I think that it's going to just continue on the same path. And I think Ranse made this point earlier that because we were, forced to be more technologically advanced in such a rapid way, that's going to provide opportunities for people perhaps to be more inclined to use arbitration going forward. Certainly within the U.S., we definitely expect an increase in all forms of alternative dispute resolution because our court systems have been very adversely impacted by the closures, and the backlogs are increasing. And so both arbitration and mediation will hopefully provide a way forward for the parties. And we're actually working with some court systems within the U.S. to assist them with that. It's hard to know sort of where arbitration is going to be seated going forward. Many of the Asian centers were growing prior to COVID, and that's probably going to continue. A little harder to predict about London. I'm not sure what your views are from across the pond, but we're not sure about the impact of Brexit and whether that's going to sort of change the perception of London as an attractive seat for arbitration. So we'll just have to wait and see. And also, prior to COVID, there had been a move in North America to promote different cities as attractive seats for arbitration. So places like Los Angeles, New York, Toronto, Miami, other locations had been, their chambers of commerce and business leaders were really actively trying to promote arbitration in the U.S., international arbitration. And California even enacted a statute to make that more attractive and easier for parties to arbitrate cross-border matters there. So I think that's going to pick up and will continue.
So one thing you said about the backlog of cases in courts. So generally, I imagine that most of the arbitrations that come before you are based on pre-dispute arbitration clauses. But given this backlog, have you seen more people agree to arbitration under JAMS post dispute?
I don't have any specific statistics about that, but it is something we're going to be monitoring, and I do expect that it will happen, and that parties will see that it's those parties, especially that have experienced the benefits of arbitration in contractual matters where there had been an arbitration clause, will find that to be an attractive option. But we don't have enough data yet about that. And I'll just also note that our experience in March was that people were much more inclined to try the virtual platform for mediations, and were a little bit more reluctant initially to revert to virtual for arbitration hearings. But as they got more experience with it and became more comfortable with it, then that started to open up, and now the arbitration proceedings are much more prevalent.
So same question for you, Ranse. Any predictions?
I would say the predictions are think about innovation, and innovation. And I think that it's really about what is it going to look like in the future. And as we said earlier on, the arbitration practitioners were pushed into how we're working now. And I think that even with individuals being more reluctant, I think they're going to innovate, they're going to be creative, and they're going to come up with solutions and opportunities that potentially would be vastly different and would be much greater than we could even imagine. The second thing I would say is California. California, as you know, suddenly became a seat and would welcome international arbitration as of 2019. We were going through a process of promoting, of doing some awareness raising, and then of course we had March appeared. And I think that really it's the untapped well of possibility and opportunity. If you think about the size of the economy in California, and also the businesses, and also the type of industries and the type of disputes I think that potentially, if you're looking for where is there an opportunity, if you were looking at seats outside of the US, I'd say in California, it would be San Francisco or Los Angeles. I certainly would be something you would want to look at in the next 5 years.
And they also have nice restaurants in those places too.
They have nice.
So these are some of the other factors that we consider when determining a place of arbitration in our arbitration.
Important.
Clauses. Yeah.
And nice weather in the wintertime. Remember
right,
that.
Exactly,
nice weather.
exactly. All types of factors. Okay. Well, thank you both. I mean, anything else that we didn't cover that you wanted to say? Did we exhaust everything?
No, just say thank you very much for inviting us. Yes.
Of course. Kwadwo, anything else?
Nothing else from me, but thank you so much to both of you. We've certainly learned a lot, and I'm sure our listeners will have done as well.
Well, it's a pleasure. We appreciate the opportunity.
Thank you very much.
Thank you.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo Sarkodie or Charles Harris, you can find them at the Mayor Brown website, mayorbrown.com. Also, to learn more about other Mayor Brown audio programs, please visit mayorbrown.com/podcast. Thank you for listening.